Most law students believe legal research means reading judgments, collecting case laws, and citing as many cases as possible. This belief is wrong. Legal research has very little to do with how the research is taught in law school. Legal research is not about knowing the law, it's about finding what helps my case, and equally important, what does not. If you don't know this difference early, you will spend years doing a lot of work which will look impressive on paper but will be useless in court. And that's what this lesson is about. In law school, legal research is taught as an academic exercise. You are expected to read everything. You are expected to understand everything and show how much you know. In litigation, the court does not care about how much you know. The court cares about whether your research answers the issue before it. A judge will never ask, has this lawyer learned or read enough judgments? No. But the judge will surely ask, does this research help me decide the case? And that difference changes everything. Legal research in litigation is issue driven, not subject driven. You do not start with, let me research the entire law on this topic. Instead, you start with, what is the exact issue I need to answer today or tomorrow? Sometimes that issue is maintainability, limitation, jurisdiction, interim relief, interpretation of one clause, applicability of one judgment. Good research starts by narrowing, not expanding, and most juniors do the opposite. They widen the scope and then drown in the information. The most common mistake is confusing effort with effectiveness. Reading 50 judgments feels like hard work. Extracting one relevant paragraph feels too easy. But in court, one relevant paragraph can win you the day. 50 irrelevant citations can damage your credibility. A wrong or irrelevant citation is worse than no citation at all. This is something juniors learn late, often after an embarrassment in court. You don't have to. Judges don't read judgments the way students do. They look for applicability, factual similarity, binding value, and the ratio of clarity. Your research should make the judge's job easier, not harder. If your research forces the judge to search for relevance, I'm sorry, your research has failed. Okay, so do one thing, stop asking yourself, have I researched enough? And start asking, does this research will move my case forward? Legal research is not about completeness, it's about utility. And this mindset alone will separate you from many. In this series, we will break down legal research as it is used in litigation. No theory, no exam papers and answers, and also no tutorials. We will talk about how to identify the real issue, how to read the judgments properly, how to choose what to cite and what to ignore, and how to convert research into arguments, step by step. So, if you are a law student or a young advocate and legal research feels confusing, overwhelming, or directionless, then this series will help you to think clearly. This is lesson 1. In the next lesson, we will talk about what legal research actually means in a court case and how to begin it in the right way. Subscribe to the first brief if you want to learn litigation the way it works. Thank you.